Well, I think that's a good lead into what I'm going to be discussing. So, the speaker was mainly talking about how the DSA itself could limit the speech of Americans and American companies. I'm going to talk about the related concerning issue of U.S. states and even the federal government thinking about copying some of the ideas from the DSA, trying to make U.S. laws that similarly restrict free speech, and how would those potentially fare under the frameworks for free speech in the U.S., the two key protections being the First Amendment, obviously, to the Constitution, and also Section 230, a statute in the U.S. that operates very differently from the way the DSA does. So big picture to think about the differences. One difference is how do moderation decisions have to be made? So putting aside what speech is protected in the US versus in Europe, there's the question of what happens if speech is in fact illegal. Is the burden on the platform itself to remove it as soon as they're made aware that it might be illegal, or do they have some immunities? And that's the first very big split between the DSA, the system that now exists in Europe, versus Section 230 in the United States, which gives way more protections and immunities to U.S. companies, to social media, to potentially avoid the harms of bankrupting litigation or judgments against them. And then, in addition to that question of when do you have to take stuff down, or what are the penalties for not taking stuff down, there's the question of what actual speech is protected. And there as well, we have big differences between the US and Europe on the issues of hate speech, as was mentioned, on the issues of lies, misinformation and disinformation, on several others, on so-called incitement. The standards in the US pretty much across the board are more protective than in Europe. However, there are still some ways in which some of these laws could be upheld, and in fact, one just recently was upheld by the US Supreme Court, which I'll get to, on the issue of obscenity, essentially pornography, specifically for minors. So to start out with, how does Section 230 in the United States operate, and how is it importantly different from the DSA? Section 230 was enacted in 1996. The concern was that under the prior general rules for newspapers and such, if you engaged in some kind of moderation, if you looked at letters to the editor when they were submitted and decided, okay, we'll print this one and we won't print that one, that, under the traditional rules, put you on the hook for potential liability if the thing you ended up published, if you say, okay, we'll let this go into the newspaper, if it turns out maybe that has libel, or that in some other way violates the law, you could be sued as well as the person who submitted the letter to the editor. So in the very early days of the internet, on Usenet boards and things like that, people were essentially starting to bring lawsuits against user boards, Usenet boards, and early things like that. And there was a concern that this was potentially bankrupting or could bankrupt some of these companies. And that's one of the reasons Congress was motivated, because they thought it could essentially have a perverse incentive that the only way to avoid these judgments was not to moderate at all. And then you would essentially have, porn on user boards meant for kids and etc. It would just basically become unusable. So what does Section 230 now mean in practice? It means that it says that they will not be treated as the speaker or publisher of speech that's uploaded by outside users. So essentially, if you publish something libelous about me on X, I can sue you for posting that on there, but I can't sue X, even though they might have moderators behind the scenes. And given the massive volume of speech that's uploaded on these massive platforms like X and Facebook, LinkedIn, YouTube, across the board, you can understand how that's sort of necessary for them to avoid essentially an unending series of libel judgments. So now, Jeff Kossoff's book, The 26 Words That Created the Internet, goes into this in a lot more detail. A lot of people have defended Section 230, essentially saying it would be impossible to operate social media as a business model in the US if it didn't exist. Now, some might say the DSA is putting that claim to the test, because now we're having a very different model in Europe, where you can be liable. As soon as someone has said, hey, I think this might be illegal, as soon as someone points to it, the onus is now on the social media companies to take it down or potentially be on the hook. Are they then going to still survive? Would that undercut Section 230? Not necessarily, because there are still some very important differences between Europe and the US. Two key things to keep in mind is that the US has about twice the number of lawyers per capita as the EU. It's just a much more litigious society in general. So there's questions of not just what is the maximum level of government-imposed fines, but what's the framework in place for individual litigants to potentially get judgments, and are there any caps on those? And then the second key difference is that the U.S., the so-called American rule for litigation is both sides pay their own costs. Even if someone brings frivolous litigation against you, it's very rare that you can recoup your attorney's fees from the other side. Whereas in Europe, the much more common model is loser pays. So if someone sues you, but you win, you can get back the attorney's fees that you had to expend to defend yourself. So that's another difference that means in the U.S. it's much more important to sort of nip litigation in the bud at the early stages. It makes it much more feasible to operate these things. And I should say, a lot of American conservatives talk a good game on free speech in Europe, have criticized the DSA, but at the same time, a lot of American conservatives have been criticizing Section 230. J.D. Vance's name was invoked. He's someone who said he wants to rein in Section 230 or limit some of its protections. And I think there's some tension there, that if you start reining in Section 230, I think there would be a fear, and a legitimate fear, that it could put a lot of the business models and wide open expression, the presumption of freedom to upload on social media, at risk. So then in addition, there's the actual substantive differences. So one difference between the First Amendment versus most European speech models is this idea of incitement. It was mentioned that incitement can have a fairly broad standard in Europe. In the US, there's a Supreme Court case called Brandenburg from the late 1960s that put a very, very high bar for what speech is defined as incitement and therefore not protected by the First Amendment. It has to be speech that results in an imminent lawless action. So that particular case, the Brandenburg case, was about a KKK rally, about as inflammatory and hateful as you can imagine, where they were talking about how the white race would need to take revengeance against society. And even there, the Supreme Court said that did not rise to the level of losing First Amendment protection, because they were not inciting a mob right there to immediately start throwing bricks through windows. So essentially, up to the point, I would say in the US, if you're outside the Capitol building and you say throw the brick through the window, that's not protected, but almost anything short of that is still protected. There's another category in the US, the so-called fighting words exception, in a case called Chaplinsky. It seems like the Supreme Court isn't really happy with that precedent. It's never applied it or extended it since that decision. That's the idea that there are some words you can say to a person right in front of you, like racial slurs, that are so inflammatory the person can't be blamed for throwing a punch at you, and to avoid inciting violence, we can restrict those. Again, online, obviously you're not face-to-face, so I just don't think the fighting words exception is going to apply for online speech, and I'm not aware of any court that's upheld a restriction on online speech on the notion of the fighting words exception. Similarly, misinformation and disinformation. European laws much more restrictive of that. In the US, the Supreme Court in a case called Alvarez said in general, the First Amendment protects the right to lie. That might seem surprising. We do, of course, have some categories of specific types of lies that can be restricted, like fraud, libel, slander, but all of those aren't just about lies. They're also creating harms from the lies or getting gains from the lies. But just a lie for the sake of the lie, for the sake of wanting to pump yourself up, protected. Alvarez was a case about the so-called Stolen Valor Act that said it was illegal to say you'd won a military medal that you in fact had not won. Some gadfly in a local town went around saying he'd won the Medal of Honor, in addition to a bunch of other bragging he'd won the Nobel Prize and whatever else he wanted to say on any given night at the bar. And he was prosecuted, and the Supreme Court threw out his prosecution, saying just simply saying you won the Medal of Honor, even if it's a stone cold lie, that's still protected. So again, very much higher bar. And also in addition, what's an important difference in the US is courts are much more afraid of the government getting into the business of deciding what's true and what's a lie. There was a case from the early 2010s where Ohio tried to pass a law, we called it the Truth Commission law, that essentially would have regulated or forbidden political advertisements with untruths in it. There was a case called Susan B. Anthony List versus Driehaus about someone who wanted to put up a billboard saying his opponent in a congressional election had voted for taxpayer-funded abortions. And there was a debate about, was this true, was this not? The Supreme Court basically said, you know, this is just too vague a standard to apply, even in the campaign finance realm, where sometimes free speech restrictions are a little bit more limited than in other realms. So that's an additional area where free speech restrictions are much more protective in the United States. What are we seeing in terms of states trying to push the boundaries on this? Hate speech was mentioned. New York State has passed a law that they're attempting to enforce. It doesn't say you have to ban hate speech, but it says that social media sites have to have an announced policy for hate speech. It's unclear exactly what this means. Would it be enough to just say our policy is hate speech is fine? It's unclear, but it says you have to have a policy for hate speech, and it says that you have to have a reporting mechanism for hate speech. This was quickly challenged by Eugene Volokh, a noted First Amendment professor, who also runs a blog which has comments, the Volokh Conspiracy, and he said he doesn't want to operate this. For one thing, he doesn't want to have to come up with a definition of hate speech. He said the term itself is inherently derogatory, so whatever you define it as, you're going to be implying that this is less favored. Just having a reporting mechanism, he said, would have a chilling effect. People would be a little more concerned about edgy comments on the blog if there's a possibility of someone ratting them out. So that litigation is ongoing. And again, it's important to stress this isn't even a ban on hate speech. This is just a reporting mechanism and a requirement to state what your policy is. And still, it's probably going to run afoul of the First Amendment. The Second Circuit Court of Appeals, which is the federal appellate court over New York, recently punted the case to the highest state court in New York, saying, can you tell us what specifically and exactly this law requires, and what is the definition of hate speech under the law, or does it have one? So that's still an ongoing litigation, but it's looking like it's going to be many years of litigation until we potentially get resolution. And certainly thus far, no court has said that this is perfectly fine. The district court preliminarily enjoined it. What's another thing that a lot of states are trying to do? They're certainly trying to limit social media in various ways. One of the big ones currently happening is age gating. So my understanding is that the DSA doesn't explicitly have age gating or age tests in the text, but it has this notion of you have to protect children from harm. And based on my research, correct me if I'm wrong, other speakers can, it looks like next year or so to implement this, there's going to be an expectation of putting age verification in, especially for social media, adult content, that type of thing. So various US states are trying to implement these right now. There's a law in Mississippi that's one of the most extreme that seems to basically be an absolute blanket requirement. You have to verify your age with an ID card or the like, and you have to be over 18 to sign up for a social media account, which is pretty extraordinary. It was blocked by a district court. Fifth Circuit took away that block. It's currently on an emergency appeal up to the Supreme Court to try to get that block back in there. And a couple key precedents for this. For one thing, the Supreme Court, except for pornography, which I'll get to in a moment, the Supreme Court has never held that minors have, in general, in society, a lower right to access speech than adults do. There have been various cases about public schools, which are obviously operated by the government and are a somewhat unique situation because those are an area where you want to create, order and discipline and actually have a purpose. So to some extent, you can, in a case called Tinker, the Supreme Court said you can temporarily limit what kids say or what speech they can display in the public school context to make sure you avoid a substantial disruption. But in a case called Mahanoy about 4 years ago, they struck down a state school district's attempt to extend that limit to social media use 24/7, because they said you have to be really wary of taking that Tinker exception to the First Amendment and spreading it to every single day of a kid's life. And so it seems like courts are wary of these sorts of attempts to rein in kids' right to access. And of course, the other big problem there is adults and the chilling effect of having to show your ID, having to show your identity. There's a long tradition in the US of the right to anonymous speech, of pamphlets. Go back to the Federalist Papers and Anti-Federalist Papers were written under pseudonyms. The Supreme Court has repeatedly affirmed the right to speak or receive speech under a pseudonym without giving your real name. When you're requiring people to show their ID cards to go to certain websites, even if they're an adult and even if they do have the right to visit that site, how many of them are going to decline to do so because of the risk of their identity being public? Many of you may have heard of the recent leak of the T app, where within less than 24 hours, like thousands and thousands of women had their IDs, names, and locations leaked. So the fear is very real. Now, so some states are starting to put age gates on. Again, none of those have been upheld by a federal court when it comes to social media. The big exception and the one area where states have had a win is pornography. So the Supreme Court since the 1960s has held that there's a level of pornography that is protected for adults, that does not reach the level of obscenity for adults, but is unprotected for under 18, is obscene for minors. The question is, how do you enforce that split? So about half the states within the last couple years put in age gating requirements for pornography, including Texas. Its law was challenged by the ACLU, went up to the Supreme Court, and just this term a couple months ago, Supreme Court upheld that law, applying only intermediate scrutiny, so not the highest level strict scrutiny where states usually lose. The Supreme Court said it's natural. We've said in the past there's a difference for minors do not have the First Amendment right to access this. The most natural way to enforce that limit is to require an ID check, just like you would to get a driver's license or a marriage license or buy a gun or exercise other constitutionally protected rights. But again, Justice Kagan in dissent said there's a big difference between flashing a card to get into a club or flashing a card at the physical bookstore versus uploading your driver's license and again having the risk of leaks. But given that precedent, it's now pretty clear that age gating for pornographic websites is going to be allowed. These are likely, given that they're only applying intermediate scrutiny, most of them are likely to be upheld by the courts like the Texas law one was. But it's important to stress the reasoning was limited to pornography, and I don't think that reasoning extends to other areas of speech where the Supreme Court has held that age does not make a difference. So we've got differences in what's truth and what's a lie, differences in incitement. The last and final thing is just general restrictions or attempts to limit editorial discretion by social media companies. We had a couple cases out of Texas and Florida a year ago where those states tried to enact restrictions or limitations on the decisions that social media sites would make, tried to sort of limit the shadow banning or tried to enforce alleged viewpoint neutrality. It went up to the Supreme Court, and the Supreme Court said, you're running up against First Amendment editorial rights here, just like we held 50 years ago that newspapers have the right to decide what they print, what they don't print, what they put on the front page, what they put on the back page. Social media is just the same type of decisions at a larger scale and in the digital age. It's you have a First Amendment right to decide what goes on. Facebook has a right to decide, I want this post up on our site, or I don't want this post up on our site, or I want this boosted, or I want this shadow banned. It's all within those First Amendment editorial rights. The Supreme Court did not finally decide did these laws violate it because they noted there just wasn't enough facts yet about what does it apply to. Yes, it applies to social media, but does it also apply to business apps like Yelp or Uber or Etsy or those types of things? So it went back down to get more details about that. But given that precedent, given what the Supreme Court and Justice Kagan's majority opinion said, it seems pretty clear that restrictions on editorial choices by social media companies are likely to be struck down as violating the social media companies' First Amendment rights. Again, very different from the European model. We're seeing some states like California have the so-called age-appropriate design code. Again, the use of design is an intentional attempt to say, we're not dealing with speech, we're dealing with like product design. We're dealing with the problem that you're designing this in an addictive way. But however you phrase it, however you name it, essentially it all gets back down to editorial choices. Newspapers are designed with attention-grabbing headlines on the front to get you to read it. Social media, yes, it's designed with the things you want to see the most at the top to get you to keep scrolling. You might say that that's not ideal. You might say that that's addictive. But just like for newspapers and magazines in the National Enquirer, that's First Amendment protected in the U.S. So again, we're seeing those attempts to restrict editorial choices so far consistently either be struck down or be sent back to get more details about what they apply to. Lots more to talk to, but I'll pause there. Thank you.